But I think we should go ahead and get started then. So thank you all again for joining. Good afternoon. Today we've got a short training on worker rights to information that is brought to you through a collaboration between the Iowa Federation of Labor and the University of Iowa Labor Center. I'm going to go ahead and start sharing my screen now so that we can see this. You can see this presentation. And the Federation of Iowa Federation of Labor has sponsored this training, and so I want to thank them for that. And the University of Iowa Labor Center will be delivering today's program. My name is Guillermo Morales. I'm the newest labor educator with the Labor Center. I, along with Paul Iverson, will be presenting for you today. I first just want to share that the Labor Center's mission is to provide educational programs and research support to Iowa's working people and their organizations. It's been doing so since about 1951. We conduct education and training programs in primarily three ways. We have on-campus programs. Now they're, virtually on-campus programs that we deliver on a variety of worker and union-related topics like workers' compensation, union stewards, financial officers, bargaining trainings, things like that. We also collaborate, much like with this program, with organizations like the IFL, local labor federations, and others to deliver programs for their affiliates on worker-related topics that they have identified their members should be trained on. Finally, we work with local unions, worker groups, and community organizations to design and deliver education and training programs that they have identified a need for. As reflected in our mission, we also conduct research on worker-related issues. So if you have a question about a worker-related topic you would like us to look into, please reach out to us and let us know. We can be reached at labor-center@uiowa.edu or at by phone at 319-335-4144. And I also want to point out that we have a variety of useful resources available for free through our website at laborcenter.uiowa.edu. So you should also check that out. And while you're at it, check out our Facebook page where we post updates to the resources that we have, and also our YouTube channel where we post useful videos that we've produced, as well as recordings of meetings and webinars just like this. Now that we have that out of the way, let's talk about how we are going to go about conducting this training. So let's talk about some logistics. If you have a question at any point during the training, please either type it in the chat function or raise your hand, and we'll take up the questions as time allows. So you can access the chat box from the toolbar by clicking on the chat icon. A window will appear, and you can type your chat into there and then click enter, and it will send it. So you can submit questions that way. In addition, you can raise your hand. You can raise your hand by clicking on the participants icon in the toolbar. A window will pop up, and you should have an option there to raise your hand. Your toolbars and boxes might not look exactly like this, but this will give you a general idea of where to find those tools. So occasionally we're going to go ahead and ask for your input. Ask you to answer a question, or ask you to share some thoughts and your experience. And if you'd like to share something, please raise your hand and we'll call on you to unmute yourself and then allow you to share your thoughts. I hope that all makes sense. I'll give you just a few seconds now to kind of identify those functions on the Zoom platform. So go ahead and explore if you aren't familiar with this platform, and see if you can find those functions. So we're going to go ahead and put that to a test. By raising your hand, I'd like you to tell me how many of you have made formal requests for information in the past. Okay, either nobody knows where the function is or nobody has submitted a request. I don't see anybody raising their hands, at least on my first screen. Okay, so that's another option. You can raise your hand, you can turn on your video and raise your hand and we'll see you that way. Thank you, Cornelia, for doing that. All right, so let me make sure there's nobody still in the waiting room. Looks like we're good there. So now let's talk about what we're going to be reviewing today. Provide you a little bit of a roadmap about where we're going. We're going to really cover just 5 main topics. We're going to cover legal rights to information, including those under OSHA and other labor laws. This is going to include a general overview of the rights under the law and the types of information that can be requested. We're also going to consider the applicability of other relevant laws such as HIPAA and then the ADA. After that, we will take on, what the elements are to an effective request for information. In other words, what your request for information should look like when you submit it to an employer. So let's go ahead and get right into it. Now I'm going to turn it over to Paul to cover some legal rights to information. Let me give him access to this real quick. All right, Paul, you should be ready to go.
I'm in control now. And hopefully, there we go. That's one thing, being in control of Guillermo's screen, it takes more clicks to move from thing to thing. So we're going to start out with rights to information under OSHA. And this rights to information workshop is, is talking about in the age of COVID, but there are some basic information rights that we want to go over that apply throughout, and then give you some more particularized information that might relate to how that would come up under in the context of COVID. But let's start out with, because one of the areas in which employees, workers have rights, unions have rights, is hazardous chemicals, hazardous substances in the workplace. And that still applies, and I like to start there just because that people need to know that they have the right to know what it is they're working with and what dangers it might cause. So employees have the right to know about hazardous chemicals that they are coming into contact with, and to receive training on the physical and health hazards of those chemicals, what they need to do to protect themselves from exposure. And it is the employer's obligation to provide that training. It's the employer has to have a written, complete hazard communication program that includes information on container labeling, how containers that contain dangerous substances will be labeled, safety data sheets, which they have to keep on all chemicals in which you might come into contact, and how they're going to go about worker training. So even if you are not represented by a union, an employee has the right to see the written, complete hazard communication program that each employer is required to have. And they're entitled to this worker training on the physical and health hazards of the chemicals and how they can protect themselves. One thing I wanted to point out here is in recent years, OSHA has made a push to try to make these warnings more understandable to the average person. So one of the things that they've done is to go in container labeling, trying to go to pictograms, international symbols, so that even if you don't understand the language that's written under it, you can see the people getting to know these symbols that are being used on containers worldwide. Then if you are a recent immigrant that doesn't speak English, it's working in a factory where there's 17 languages spoken, you'd at least be able to see these pictograms and have some idea that I maybe should avoid the flame, you know, I maybe should avoid that because it's probably going to start a fire. The skull and crossbones is pretty universally known as this is going to kill you. So they're going to these, containers that you use should have these international symbols on them so that it's easy for people, no matter what language they speak or what level of literacy they have, to see where dangers are. And warning signs are supposed to be now more direct and in simpler terms. So this is the example of one of the warning signs that complies with OSHA requirements now. Cadmium may cause cancer, causes damage to lungs and kidneys, wear respiratory protection in this area. So it's just right out there. This is what can happen to you if you come into contact. This is what you need to do. That's the level of warning and the type of language that OSHA requires. So what is in the COVID situation more likely going to come up is the right to information about injuries and illnesses. But that applies to injuries and illnesses of any kind that are work-related. And so COVID is just one set of those. The employer has to keep a log of injuries and illnesses, but not really small employers. Employers that have had at least 10 employees at any time in the last year. So it could be a catering service that normally just has 2 or 3 people, but when they have a big event, they have 20 servers because it's a big event. They would still be of a large enough size that they would have to keep a log of injuries and illnesses. They have to not only keep this log, but report it to OSHA, or they have to keep the log, I'm sorry. They have to report to OSHA all worker deaths and all incidences that hospitalize 3 or more workers. So if you have an exposure that is sufficient that 3 or more are hospitalized as a result of it, then they have to report that to OSHA. And that's whether it is a large accident that injures several people, or if it's an exposure to a chemical, or if it's an exposure to an infectious agent and a number of people get killed. If 3 or more workers are hospitalized from the same incident, it's got to be reported to OSHA. And OSHA has to be allowed access to those records at any time. And then there is a summary of this is called an OSHA 300 log. There's a summary that has to be posted each year so that it's readily visible, posted where employment notices are posted. And so for every employer obligation under OSHA, there are employee rights, or, vice versa. Wherever there are rights, there's an obligation. Wherever there's an obligation, there's a right. So the employees have the right to review the current injury and illness log, as well as logs going back for the past 5 years. Employees have that right, separate and apart from whether they're represented, but union representatives have that right as representative of the employees to see these as well. Going back 5 years, they can't just say, here's the current log. Everybody has the right to view the annually posted summary. One thing I will say on the injury and illness logs, that has been a big area of controversy with COVID. OSHA kind of went back and forth on, do you have to log people getting sick with COVID? For a while it was, yes, do it all the time. Then it was, no, never. Where they've settled is the employer has to record on the log people contracting COVID-19 if it is work-related. And that's the big loophole that you can drive a truck through. And so employers are always going to claim, well, it was the barbecue he went to over the weekend, or it, was visiting some friends the other, always claim that there's something outside of work that caused the COVID. And so that's something that we constantly have to be monitoring, that if people are getting COVID and it seems obvious that work was where they got it, but it's not showing up on the logs, we should be challenging that now and into the future. Okay. Exposure records and medical records will come in here a little also in the COVID situation, but in other situations. And so if there was exposure that led to 3 or more people being hospitalized, has to be reported to OSHA. But there are exposure records that the employer must keep as well. They have the duty to, come on, move along, there we go. So first, they have the duty to monitor exposure to toxic substances and harmful physical agents, which people in the construction industry will know could be silica, could be sawdust, could be, it doesn't have to be something toxic, but something that could be harmful. And this would include infectious disease. So it never used to include bloodborne pathogens, but after HIV/AIDS became an issue, then enough worker response, finally, bloodborne pathogens became part of the things for which you had to monitor. So you have to monitor chemical substances, metals and dust such as lead, cadmium, and silica, biological agents such as bacteria, viruses, and fungi. And that's where COVID comes in. COVID is coronavirus disease is what COVID stands for. The 19 stands for 2019, when this disease related to coronavirus was first found. It is a novel coronavirus. It was not existing before. The virus that causes it is called SARS coronavirus 2. And so that is a biological agent that if people are exposed to it, the employer has to monitor whether employees have been exposed to the SARS coronavirus 2. And interestingly, the employer has to monitor exposure to things such as noise, heat, cold, repetitive motion. So all sorts of things more than just chemical exposures. And then the employer also has an obligation in certain situations to provide medical exams when there has been an exposure or when there is the chance of repeated exposure, and to provide workers access to their exposure and medical records. So you get to find out what you've been exposed to. They can't just record that there was an exposure that included you and not tell you about it. Well, technically they cannot tell you about it, but you have access to find out. So employees have the right to examine and copy exposure records. And for unions, you have the right to see those records for the entire bargaining unit, not just for individuals. Examine and copy their own medical records, and Guillermo will be talking about HIPAA later as it might relate to getting those for someone other than yourself. But specifically under OSHA, employee representatives have the right to those records. And so records that are related to exposures and examinations to see if the exposure caused injury or illness are things that are supposed to be accessible to employees and their representatives. And that employee representative doesn't necessarily have to be a union. So anybody that's in this workshop that works for a service organization or a nonprofit, if there are workers that come to you and they're not represented by a union, you can be designated as their representative and have the right to look at records on their behalf as well. You won't be able to go on OSHA inspections, only union representatives can do that. So that's OSHA. Let me pause just briefly to see if there's any specific questions on OSHA information rights before I move on to the National Labor Relations Act. Okay, then I will move on. So under the National Labor Relations Act, employees have the right to information through their representatives that they've chosen to bargain on their behalf. So under the National Labor Relations Act, employees have some basic rights. They have the right to organize, form, join, or assist unions. They have the right to negotiate collectively through the representative of their choosing and to participate in other concerted activities. And I emphasize negotiate collectively here because the duty of employers to provide information to employees is considered part of the duty to bargain in good faith with the employees. The board recognizes and courts recognize that you cannot appropriately bargain over terms and conditions of employment without information, without correct information. And since most of that information is in the control of the employer, an aspect of the obligation to bargain in good faith is that you have to provide the information that you have about wages, hours, terms, and conditions of employment to the employees and particularly through their bargaining representative. So just a little bit quickly about the interplay between OSHA and the National Labor Relations Act. Under the National Labor Relations Act, employers are required to bargain over wages, hours, and terms and conditions of employment with their employees. Safety and health issues are terms and conditions of employment, so they are a mandatory subject of bargaining. Employers have to bargain over them. So OSHA it's one thing that's really good. OSHA is a one-way ratchet. You know, it's a floor that they have to give you, but you can negotiate for better. They can't even propose worse because you can't waive OSHA rights. So if you propose something better, the worst that can happen is you end up with OSHA. You're not going to end up with worse by proposing something better. And also, employees are protected when they're engaging in concerted activities related to workplace safety, such as serving on a safety committee, because it is a mandatory subject of bargaining. So there is some interplay between the NLRA and OSHA in that you can be protected in two ways for things that you're doing to promote health and safety in the workplace, protected both by OSHA's requirements of non-retaliation and by your collective rights under the National Labor Relations Act. So what can you ask for? You know, the union has the right to request and receive information for a number of purposes: monitor compliance with the contract, prepare for negotiations, determine whether a grievance exists, prepare for grievance meetings, prepare for arbitration. Also, a whole range of things that the union does in representing its members. It has a right to receive information that it can use in all of those situations. And what can that information be? And this list, you know, this is a partial list, started to list some things just to give a start. The important thing is any documents that may be relevant, may be relevant. You don't even have to show that they are relevant. They don't have to be necessary. They just may be relevant to a grievance investigation or negotiations. The employer has to provide. And you know, specifically with health and safety records, you've got the OSHA rights that employees have and that the union can have as representative. But then you also have the National Labor Relations Act rights for the union to receive that information as the representative of the employees, and failure to provide information charges is one area that the National Labor Relations Board in any administration takes seriously. And so being able to file an unfair labor practice charge to force the employer to give you information actually may have a quicker effect than filing something with the Department of Labor that they're violating OSHA. And so all of the things that you get under OSHA, you can get, but anything else that may be relevant to your negotiations, even if it's not required by OSHA, the employer doesn't have to create documents for you. But if they have documents, then they have to provide them to you. So you can't say, well, we want the answers to 18 questions that they just don't have the answers to. They don't have to research it and do a report for you. But if they keep track of things beyond what OSHA requires, they have to give you that information, even if it's not required. So the rights of a union to get health and safety information is more extensive than the right that employees or employee representatives have under OSHA. It's to any kind of records that the employer might keep that would relate to the health and safety of the employees. For the NLRA applies to private sector employers. For public sector employers, for public employees in the state of Iowa, the same rights apply, but the rights are related to, you know, as I said, the duty to negotiate in good faith. So in Iowa, unfortunately, if you are not, other than public safety employees, if you're not a public safety employee in the state of Iowa, then all your employer has to negotiate over is base wages. So the only information that you're entitled to is wage data. For public safety employees, police, firemen, EMTs, you know, those types of employees, they are still entitled to much broader information, but again, related to the things that are mandatory subjects of bargaining. So it's never been a mandatory subject of bargaining under the public sector in Iowa. Retirement has never been a mandatory subject of bargaining. The state established HIPAAs and police and fire pensions, and they don't have to negotiate over those. And so you have rights as a member of those, as someone receiving benefits from those pensions to get information, but the union doesn't have the right to that information for negotiations because it's not a subject of negotiations.
Paul, I've got a question about that, if that's okay. So, but if in fact the employer has negotiated permissives, then whatever they've negotiated on permissives, that's fair game in terms of information requests.
Yes, yes. Oh, thank you, Guillermo. That's a very good point. The only mandatory subject of bargaining is wages or base wages. There are illegal subjects of bargaining, a few of those, but most things are permissive, and some public employers will negotiate over permissives. They do have the obligation to provide information, accurate information related to the permissives. The only potential issue there is it being a permissive subject of bargaining. The employer can just refuse to bargain over it. And so, you know, if they've agreed to bargain over it, they should be willing to give you documentation to back it up. But they would probably, if you get into a fight with them and it gets to the point that you want to ask PERB to require them to give the information, they probably say, yeah, we no longer want to negotiate over that, rather than fight out the information request. But if they are agreeing to negotiate about permissive topics, then it's just part of that they got to give you information. And so hopefully there won't be a lot of disputes. But if you're trying for something that might be pushing the envelope a little bit, you might need to be a little, there's a potential for some issues. And do we have anybody that is in this workshop that is a federal employee or represents federal employees? Doesn't look like it. So I'll just flip really quickly through this just to let people. Oh, okay, so we do have one person. With federal employees, same thing where it's related to the duty to bargain in good faith. The FSLMRS is the Federal Sector Labor Management Relations Statute, the federal equivalent, the equivalent for federal workers of the NLRA. Under that, it's very explicit that there is a duty to provide information that is separately set out in the statute, rather than something that has been read into the statute through cases, which is the case with the NLRA. So, but it has a slightly different standard. So again, it's part of the duty to negotiate in good faith. They have to provide information which is normally maintained by the agency in the regular course of business, which is reasonably available and necessary, not just may be relevant, reasonably available and necessary, and does not constitute guidance, advice, counsel, or training provided to management officials. So you can't ask for their strategy in negotiations, basically. So they have the duty to provide that information, and the federal sector unions have the right to get the information, but it is, information requests are much more formal than in the private sector. So the Federal Labor Relations Authority, the equivalent of the National Labor Relations Board for the federal sector, has adopted what they call a particularized need standard. And so you need to specify your need for the information. So the information request must include the specific information that's requested. And if you've ever represented federal employees, every form has a form number. And you better find out the form number and ask specifically for what form, because management can be really dumb. And if you describe something, they'll say, we don't know what you're talking about. But if you say, well, we need form 44-333A, then they have no choice. So the specific information requested, what you are using it for, what you need it for, and a statement of how this information relates to the union's duties as exclusive representatives. You need to set out a reason for the information that you need, more than just this information may be relevant to bargaining. And there is a form that the Federal Labor Relations Authority has established for information requests, which you can download from the FLRA website, flra.gov. So it's, if you can, it's best to just use the form, because then then the agency really can't complain. Well, this isn't in the proper form, you know, no, it's right in the form that the FLRA has established. So with respect to information requests, management has the obligation to respond and articulate its concerns. And if they say that they can't produce the information for some reason, they have to say why. And if there are concerns, then the union has to respond and they negotiate. Failure to respond is a ULP, just as it is under the NLRA. Well, again, there I mentioned the form. One thing that is the same here, the obligations with respect to information requests are the same under the NLRA. They're just not specified in the statute the way that they are under the federal sector. Management has the obligation to respond to your request for information, and if it doesn't give you the information, it has to articulate why. Why is it that they feel that they can't give you the information? They can't simply refuse. And if they have raised concerns, then the union has to respond in a way to try to work out what the issue is and to get what the union actually needs, rather than, you know, if there is a legitimate concern. And I'll just give an example from when I was, before becoming a labor educator, I was a lawyer that represented unions up in Minnesota. And I represented a union that represented employees at the Gillette plant in downtown St. Paul, Minnesota. And one of the things that was made at that plant was men's deodorant. And it was the sort of cake kind underarm deodorant. I don't know if anybody ever reads the ingredient labels on things like that, but for this I had to. And it turns out that the active ingredient is like 0.001% of the ingredients in underarm deodorant. So if you don't have the active ingredient, you have a whole bunch of talc. And so there was a batch operator whose job was to make sure that everything was mixed in the right proportions at the right time. And on one batch, he forgot to put in the active ingredient. And a whole big batch, and these are big vats, was destroyed. And so he was fired. But it turned out he was the newly elected president of the plant local. And so we were really like, okay, what's going on here? And he said, that he knew of 10 people in the last 5 years that had made the same mistake and nobody was fired. So for every batch, there's a batch record, which is a 3x5 sheet, and it has information about the batch. So it would show on the batch record that that mistake had occurred. So we asked for all of the batch records going back 5 years. Well, as it turns out, that's a lot of batches. And so what I call a banker's box, a box that you would get paper in, reams and reams of paper in, 17 of those, these 3x5 sheets stacked on top of each other filled 17 boxes. And the employer said, we'll give you copies of the batch records, but you got to pay us $25,000 for staff time and copier machine use and paper. We're not going to give it to you for free. So that was a legitimate concern with that amount of paper. And so the union, it's like, we're a plant local. We're not a rich local. We're not going to pay $25,000 for this. So we talked about what we really needed and said, well, we don't need copies of all the batch records. We just need the batch records that show this mistake. So we just need to look at the batch records. So we said, no, just let us look at the batch records. We'll mark the ones that we want copies of, and you can copy the ones that we really need. So they screamed and hollered and weren't going to do it, but when we threatened a ULP charge, they finally brought all the boxes in, and 4 union representatives spent 8 or 9 hours in a conference room going through all of those batch records, and they found 13 in the past 5 years that had the same mistake, and marked those for copying. The point being that just because the employer says, we can't do that because X, try to see if there is a way that you can get what you need, see what you really need, and can you get around? Because in that case, when we asked them to copy these 13 batch records, they showed their lawyer what we were asking to have copied, and the next day they reinstated the union president and we agreed to drop the grievance. So we got the information that we really need. So management has the obligation to respond and articulate its concerns, but then that starts a new negotiation. So you negotiate over the information that you need for negotiations. Yep, and that wraps up those. Any questions or anything about rights to information under the under collective bargaining laws that anybody would like to cover before I hand it over to Guillermo?
If you can't raise your hand or type your question in the chat, feel free to unmute yourself and ask your question. I don't see any. Okay, well, I'm turning it over to you, Guillermo. All right, let me just make sure nobody's raised their hand. Yep, I think we're good. All right, so I'm going to take control back. Let's see, do I have control now? I do. Wonderful. So thank you, Paul, for covering that. I do want to let you all, we did get one question in the chat about just general kind of housekeeping in terms of whether this slideshow will be available. So you can either send us an email, shoot us an email requesting the PowerPoint itself, or wait for this video. We'll be posting this video on our YouTube channel here in a couple days. So that's also available to you. So let me make sure I've got, I think,
Yep.
actually did not wrestle control away from you, Paul. So let me go ahead and do that now real quick. All right.
Yeah, it still says I can control.
Let me take that back.
Hey, once you give me control, it's hard to get it back.
All right. So I think I've got it now, Paul.
There.
All right.
You got it.
Wonderful. Thank you. So I'm going to be covering how HIPAA and the AD apply in the context of requests for information. Then I'm going to go ahead and move on to the elements of effective requests for information. You know, in the current COVID-19 environment, the importance of having actionable information concerning the safety measures implemented, safety policies in place, and the potential spread of COVID-19, it simply can't be overstated. It's of paramount importance to worker safety. And so I think it's very important that we cover these topics. So let's go ahead and start with HIPAA. In terms of HIPAA, you know, we've heard that there are a number of employers out there that have been trying to hide behind HIPAA, which is the Health Insurance Portability and Accountability Act, to avoid providing relevant information. However, HIPAA generally does not apply to medical records maintained by an employer, although there is one caveat that I just became aware of. Thank you, Paul, for sharing this additional information. But what I want to kind of start by saying is that HIPAA privacy rules apply only to health plans, healthcare providers, healthcare clearinghouses, and their business associates. These are, you know, essentially cover what are called covered entities. And so healthcare clearinghouses are things like billing services, repricing companies, health management information systems, entities like that essentially process health information received from other healthcare entities. Business associates are individuals and entities who conduct business. They're essentially contracted to conduct business on behalf of the covered entities. These contracted businesses essentially come into contact with personal health information through the activities that they're contracted for. Again, only those covered entities, it only applies to those covered entities directly. But even for those covered entities, it does not apply to them in their capacities as employers. So, you know, when an employer has health information in its role as an employer, that health information is not protected by HIPAA privacy rules, even if the employer also happens to be a healthcare provider or any other covered entity. Again, there is one caveat to that, and we'll get to that shortly. Disclosures that are required by law are also not protected by HIPAA. And so the US Department of Health and Human Services has explicitly identified disclosures legally required in the course of collective bargaining as disclosures required by law. So to the extent that a covered entity is required by law to disclose protected health information to collective bargaining representatives under the NLRA, it may do so without receiving prior authorization. So here's the caveat. Covered entities which provide medical records to employers are required under HIPAA to get assurances from the employer that the information will be held confidential. So that is the one caveat. So I think, you know, if you're in the situation where the employer is pushing back and saying that the information that you're requesting is protected under HIPAA, I think the first question is, you know, where did they receive the information? If they received the information from the employees themselves, then that's not going to be protected by HIPAA. On the other hand, if they receive the information from a covered entity, then they may have given assurances to receive that information that it will be kept confidential. So that is something to be mindful of. And so you want to ask, you know, where the information was obtained. So that's essentially HIPAA. I want to talk a little bit about the ADA, because I think the ADA does put up a few more substantial roadblocks to getting information. We will talk a little bit about ways to get around it, though. So under the ADA, employers with 15 or more employees must maintain all information about employee illnesses as confidential medical records in compliance with the ADA. The ADA does require that all medical information about employees be stored separately from their employee personnel files. So this is a tactic used to limit access to confidential information, because employees and their representatives, their union representatives do have the ability under the LRA to access personnel files. So, this information, this medical information, is supposed to be stored separately. Now, the ADA doesn't permit broad disclosure of medical conditions of specific employees. One thing to note also is that broad disclosure is also not recommended by the CDC, but the CDC does specifically recommend that employees be informed of their possible exposure to COVID-19 in the workplace. So the CDC is in fact recommending that if an employee in the workplace gets exposed to COVID-19, they should be informed of that possible exposure. So given the disclosure prohibitions under the ADA and the duty of employers to provide relevant information, there's a clear potential for conflict between the two laws and the respective requirements. But when such a conflict comes before the NLRB, what it does is it tries to balance the need for the relevant information with the need for confidentiality. And what they will often do is require the employer and the union to negotiate an attempt to meet both interests. So what does that look like? I'll go ahead and put this to you. If you'd like to provide your insight on this, please raise your hand or feel free to unmute yourself and chime in. But I want to put this to you all. What kinds of things can you do with respect to confidentiality in order to maintain that in some way and still get the information you're seeking? What are some things you could do? Does anybody have any ideas? Doesn't look like anybody's unmuting themselves to talk. So
I will unmute myself then.
Wonderful, Paul, thank you.
Just one thing that I want to, when HIPAA gets thrown at you, what HIPAA protects is individually identifiable medical information. And so one thing to look at is, do you care the identity of the particular person? So for instance, if you represent nurses and a nurse is accused of not giving medication to a patient in a hospital room as prescribed, and the nurse says, I noted it in the patient's chart, the employer may say, well, we can't give you the patient's chart. That HIPAA that would violate HIPAA. Well, you don't need to know the name of the person. You just need to know, you know what shift the nurse was working and what room the person was in. So you just need the chart for that room at that shift and take out the patient's name and the patient's number. You just need to see the chart for that room at that time. You don't need any personally identifiable information. And that way you just get around HIPAA. Now they have no excuse for not giving you the chart. So one of the things that you can do to protect confidentiality and yet get the information is, what part of it is confidential and do you really need that part? And so always be thinking about that as to, so if you're looking at, how many people in the last 5 years have missed time due to a particular reason. you may not need to know the names of the particular people involved. You just need to know the raw numbers for negotiations. If you're going to, whether you're going to ask for something, because so many people are missing because of this reason, maybe we need to do something about that. You may not even know the names of the people. You just need to know the numbers. So always look for what is it that you really need to get around the confidentiality concerns.
Absolutely. Thank you, Paul. So, that's fundamentally it is, you can, inform the employer that you don't need names. So remove individual names and other personally identifying information. You can, kind of on that same theme of thinking about what it is you need, you can also have them focus on a particular location. If you don't need the information from the entire bargaining unit, you just need it from a particular building, you can focus on a particular location. That might make it a little bit easier. Of course, you can always get individuals to sign releases to enable you to get the information as well. The next two are perhaps at least with regard to COVID-19 might be not ideal situations, although I think, you'd have to weigh again, how badly you want the information and what you plan on using it for. In this COVID-19 environment, speed is really key. You don't want to have to wait around to get information. And so it's really important that you think about ways to kind of speed up the employer's response because, what we're talking about is worker safety, at risk here. And so we want to try to get this information as fast as we can. And so we may want to think about how we structure our information requests to already kind of anticipate some of this pushback. But you could guarantee that the information will only be used for representational purposes or also only shared on a need-to-know basis. I think in the COVID-19 environment, you could make an argument that the employees need to know what this, what the transmission, the spread of COVID-19 is in the workplace. And so you could argue that sharing it with all the employees is something that they need to know. So there are ways that you can go about getting this information and still protecting confidentiality when the employer pushes back against you for that reason. Again, you might want to also, depending on how quickly you need the information, again, decide that you want to craft your information request already recognizing this potential problem, and then making your request reflect that you're okay with having this personally identifiable information redacted from the information that you're given. So those are things that unions can do. What about things that individual workers who are not represented by unions? What can they do? Well, they can encourage employees to share what they know about the safety issues and the spread of COVID-19 in the workplace with other workers. So this might help workers track for themselves the spread of the virus in the workplace. And this information could be useful when it comes to, for example, workers' compensation claims, unemployment claims, when the workers feel it's a workplace that is too unsafe for them to work. So having this information, the information that the workers know, could be very useful. And of course, they have the right to their own, the records about themselves that the employer has. So they can request that information as well directly. They can record who they interact with. They can record the safety issues that they've identified and that they've brought to the employer's attention. And they can also record the employer's actions or inactions. Again, this information will also help should there be unemployment claim or workers' comp claim, something along those lines. So, you know, when they decide that they can't work because it's just so unsafe, and they decide not to work. So something else they can do is report illnesses and infections to employers. When they do so, you know, they want to try, as Paul indicated earlier, OSHA is now saying that it only needs to be reported on the OSHA 300 log when it's, you know, a transmission that occurred at the workplace. So, you know, when you do have those kinds of situations, and it's easy to show that the transmission took place at the workplace, you know, you can encourage individual workers to report the illness and infection to the employer, and then, you know, after some short amount of time, then check to see that the OSHA 300 log does in fact reflect the report that was made, in order to verify the employer is in fact tracking them as required by OSHA when it is required. What else can they do? Well, they can talk to community leaders about the threats to public health and engage in concerted activity. So we have seen how unsafe conditions in the workplace have caused public health emergencies in local communities. We need only look at what's happening in meatpacking to see examples of this. You know, when employees engage in collective action, concerted activity, that's when two or more employees act together for mutual aid and protection, such as for their health and safety. They become protected against retaliation under the NLRA. So it's a good idea to encourage people to act in concert, encourage two people to act together, two or more people to act together when they're raising health and safety concerns, or where they're engaged in any other concerted activity. Finally, they can also consider filing a complaint with OSHA. When an employee files a complaint with OSHA, they are then protected against retaliation from, you know, by the whistleblower protections of OSHA. So while, you know, their individual workers' ability to get information might be limited in some ways, there are many things that they can still do to get information and to protect themselves and their communities. So now let's kind of bring it back to the union's right to information. So I'll kind of put this out to you at the risk of nobody chiming in again, but we'll go ahead and give it a try. What do you think a request for information should look like, or what should it contain? I'll go ahead and open this up and let you all chime in if you'd like. Feel free to unmute yourself if you'd like to share. All right, it looks like we got a bunch of shy people on the call today, which I'm incredibly surprised by. But well, what should it contain? Well, first of all, what it should look like? Well, it should be in writing. Making sure that your request is in writing is going to help you show that you've made the request. So if you are making a formal request for information, it should definitely be in writing. You don't want to rely on verbal requests for information and hope that they can be, you know, will be enforceable. You want to make sure that you have a record of it, and so you want it to be in writing. And so kind of this is kind of fundamentally what a you know, information request might look like in a COVID-19 environment. So you're going to want to make sure that it contains the name of the person that you're requesting information from. You'll want to include your name or the requester's name and title. Of course, you want a date so that you can tie back to when you made the request. Of course, the subject would be good to have there just to give some insight into what you're looking for. Start getting into the meat of it here, where you've got you know, the statement that indicates why the information is relevant to either preparing for bargaining, bargaining or the administration of the contract. So here you'll see that it's to investigate a possible grievance. That second sentence in red there kind of piggybacks on it and indicates why it's needed as well. You know, you can't adequately enforce a contract or investigate the issue without that information. So those are good statements to have in a information request. Of course, kind of the main part of your request is what it is you're requesting. So you want to have a list of the information that you're requesting, and you know, if a particular format is needed and it exists, you might want to go ahead and ask for it in that format. And then incredibly important, I think, is to also have a statement in there that provides a deadline. You know, normally, I think in normal contexts, of course, depending on the situation, you know, a reasonable amount of time to provide the information is going to be based on the amount of information that you're seeking. But I also think that in this COVID-19 environment, I think it's reasonable to expect a quicker turnover of the information that you've requested. So you can go ahead and keep that in mind as well. You know, one more thing that I kind of include in requests for information is also the contact information of the person requesting information, because this will give the person receiving the request the opportunity to reach out if they have any questions about the request. I also like to include in here a date by which they should reach out if they do have questions. I think this kind of gives me some insight into whether I can anticipate getting the request on time. It also kind of opens up the window for them to reach out sooner rather than later if they do have any questions. So I think that's a very important part to providing formal requests for information, and that's you know, providing your contact information and a date by which you anticipate to receive questions, if there are any, about your request.
Yeah, Guillermo, I really want to second that, because in my experience, if you don't put a date on, the response you get from management is always, I'm working on it.
Mm-hmm.
And they will be working on it until the end of time if you don't give them a deadline. So I always give them a deadline, and then if they don't do it, send them a follow-up letter giving them, saying that if we don't get it by this date, we're filing a ULP charge, and then you've got your record for your ULP charge, and then just file your ULP charge.
Yeah, absolutely. Thank you, Paul, for adding that. So this is kind of what a you know, effective formal request for information might look like in the COVID-19 environment. Of course, in a general, when it's a general kind of request for information, you know, you can adapt it accordingly. Of course, the information that you're requesting will be different and relevant to your issue, but you can still use this format for those requests as well. It's standard in that sense. So that's really kind of what I have for you in terms of HIPAA, ADA, and the elements for an effective request for information. That we got through this much more quickly than I anticipated we would. But what I want, what I want to share is I hope that you're leaving with a better understanding of worker rights to information and how other laws impact those rights, as well as leaving confident that you can put together an effective request for information. But before we close, I also want to kind of open it up one more time to see if we have anybody with any questions about anything that we've covered today. Feel free to either raise your hand, type your question in the chat, or if you're no longer shy and want to unmute yourself and ask your question directly, feel free to do that. I don't see any raised hands. Nothing is coming through in the chat. So I guess lastly, what I want to share then is that, I just want to thank you again for joining us today to discuss this important topic, especially in the context of COVID-19. I want to, share that, the Labor Center does have a lot of resources generally, and a lot of resources specific to COVID-19 on our Labor Center website. And so you can visit our website at laborcenter.uiowa.edu. You can email us if you have any questions at labor-center@uiowa.edu. And of course, you can give us a call at 319-335-4144. We will be posting this video on our YouTube channel. So don't forget to check out our YouTube channel and also our Facebook page, where it will likely be linked to. We do have a few questions coming in now. Let me see. We are in a union shop. So do they have to sign a release, or as a union official, could we get their medical information without it? So, so even in a union shop, I think, there are some protections to keep information confidential. You've got, the ADA and also the provision within HIPAA, where if they received it from a covered entity, they need to keep it confidential. So in these cases, you may want to also consider ways to have the personally identifiable information redacted from the information you're requesting.
There are certain situations where the union's just entitled to the information. So, for instance, on these OSHA 300 logs, the actual persons that were injured, or the name of the person who was injured or contracted the illness, has to be part of that record. That's something that was fought out over a number of years, where employers would argue that, well, we got to keep the names confidential, and OSHA finally deciding you cannot effectively deal with the injuries and illnesses if you don't have names of people involved. So if it is something on the OSHA 300 log of somebody that has contracted COVID or has suffered an injury, that name has to be provided to the employee representative. And as Guillermo was saying on HIPAA before, if it's information that, even medical information, that the employer received as an employer, it was asked for on an application or something, where they didn't receive it from a healthcare provider, they got to give it to you.
All right, thank you, Paul. I don't see any other questions, so I just want to thank you all one more time and tell you to be safe out there and take care. We appreciate it. You can catch this video. You can catch this video online in the next few days. Thank you all. I really appreciate it.